By taking the plea deal, Christian got the certainty he was so desperately craving to make it stop. The risk of time in county jail was off the table.
But the case continued to haunt him. He had a new problem, living with the feeling of being branded an animal abuser. As a cat lover, still insistent that he never intentionally harmed Storm, that her falling off the balcony was an accident, his lie to the court in pleading guilty didn't sit well with him. He couldn't shake it.
Sure, he lied to Andrea in his moment of panic and dug in on that lie and made some bad decisions. But as he said, he'd learned from that already and insisted he was a different person these many months later. Now, he was trapped in a different lie because of his arrangement with the court. Says his mom, Shannon.
He is very much about justice and just his whole life, like this something isn't right or something isn't fair. Someone did this, they deserve that. And in this case, justice was not done and it weighs on him.
What Christian and his family really wanted all along was for his innocence to be proven. A risky trial would have been the only avenue the criminal justice system offers. Even then, if he prevailed, he wouldn't be deemed innocent, just not guilty. The word innocent matters to Christian. It matters so much to him and his family that they were willing to go to great cost to clear his name. They were even willing to put him back in harm's way. You're listening to Vulnerable Creatures. I'm Lauren Hugg.
And I'm Matthew Schnooker. This is Episode 6, Seeking Justice.
When we first sat down with Christian's father, Mark, he was very frustrated about the Alford plea not being accepted. I didn't get it at first, because legally it doesn't make a difference. It's treated as a guilty plea. I didn't understand why it was so important to Christian and his father to not say I'm guilty, but to rather say I didn't do what I'm accused of, but I want to avoid the risk of being convicted at trial. But after talking with Mark and Christian, it became apparent that saying I am guilty when Christian didn't believe he was, caused Christian a tremendous amount of mental anguish.
When Christian decided to take the plea, he thought he was going to be able to maintain his innocence. The prosecutor's refusal to accept an Alford plea in court that day was an unexpected change. As we've heard, change is difficult for autistic people. Says Temple Grandin.
One of the things is that person with autism takes longer to process.
And Leanne Paskvalich.
And it goes back to kind of oftentimes the slow processing is like they're processing it in their head and it takes them a while to get the words out. But by the time they're ready to get the words out, you've moved on.
In court, Christian only had a few minutes to consider whether it was worth it to him to take the deal if it meant him having to say he was guilty.
The main purpose of accepting a plea is avoiding the risk of conviction. While it may be nice to have the option of stating innocence while taking advantage of a deal, the deal is the important thing. Maintaining innocence was so important to Christian, however, that his attorney asked permission from the court for Christian to go out in the hall and discuss this new condition with his parents. Christian told us that in that moment, he was thinking everyone was out to get him and making him out to be a monster. He would have done anything to make it stop.
Mark says he felt like he failed his son that day.
And I just seeing him through this, just a heartbreak, nobody seemed to really have his back. If our attorney was sitting right here, I would say to him, it's so hard to watch the way this went down and it looked like you couldn't do shit about it. Like the judge was barely listening and nothing slows down long enough. They're just pushing paper right past each other. I'd never felt so useless in my entire life. And I just sit there and I'm like, after all the struggles and everything he's been through and what he's overcome, and I'm like, and you're here, you're just like, you don't care. You are just cutting him off at the knees. And you don't care what he's lost. You don't care what he could lose. You don't care at all. None of you care. You just want to push the paperwork through and, we don't take Alfred pleas. Why? We just don't. And that was standing up in front of the judge when we tried to enter the Alfred plea, because the other DA said we could. So I don't know where that all got lost, but because we had 3 different DAs rotating in or out and in and in and out, like, so you just wholly reject available legal principles and policies. We just don't do them. Because what? Because you don't believe in the law? In particular with Christian, for me and for my wife, it's like we couldn't even help him. And nobody else wanted to. I never felt so helpless. Like just looking at him, watching him go through it, it tore him apart. And for him to have that lasting, look what the system did to me. I don't want him to have that. So if there's anything I can do to say, okay, maybe the system screwed you, but there's still good out there. There are people that are fighting to change this, and maybe we have to get into that fight.
So Mark decided to fight the system in 2 ways. He reached out to me to see if there was a story here, to see if a journalist and the general public would be interested in the way this all played out, to see if there was any way of holding public entities accountable for what he saw as a faulty investigation and careless prosecution. And we'll get to that in our next and final episode.
He also decided to fight within the legal system, hiring Catherine Spicer, an attorney specializing in post-conviction relief. She tells us post-conviction work comprises 90% of her job, and she's the only person in her geographic area of Colorado doing it, that she almost exclusively takes court appointments or appointments through the Office of the Alternative Defense Counsel. That puts Christian's case in the rare 10% of her private casework.
Spicer, along with private investigator Troy Zook, who we met in episode 3, set out to reinvestigate Christian's case, gathering evidence to support a motion to set aside Christian's guilty plea. The legal basis for the motion would be ineffective assistance of counsel, arguing that Christian's first attorney, Bryson Perkins, didn't do a thorough enough investigation to adequately negotiate a favorable plea bargain or to advise Christian on the risk of accepting a plea deal or going to trial.
To win an ineffective assistance of counsel claim, the U.S. Supreme Court in Strickland v. Washington said you have to prove 2 things. 1, that the original attorney's work fell below an objective standard of reasonableness, meaning a competent attorney would have done better work. 2, a defendant must prove there is a reasonable probability that the outcome of this case would have been different with a competent attorney.
Quick digression. Why doesn't everyone who gets convicted at trial try this?
A lot of defendants do try. You might as well try to get your conviction overturned, especially if you're serving a lengthy prison sentence. It's not like it could make things worse. Winning an ineffective assistance claim is tough, though, because a court isn't allowed to fall prey to what Strickland calls the distorting effects of hindsight. It must evaluate conduct from the attorney's perspective at the time the work was being done. The defendant has to prove that the attorney's actions couldn't be considered a sound legal strategy. As the Supreme Court points out, even the best criminal defense attorneys would not defend a particular client in the same way. According to legal advocacy group the Innocence Project, the Strickland standard creates an extremely high burden on the defendant. Courts must be highly deferential to the trial attorney's decisions.
Translation. The court is worried about defendants trying to call mulligans and ask for do-overs by blaming their attorneys if they don't get a favorable outcome the first time. A high standard of proof is meant as a buffer against that.
Yeah, in May 2022, the Supreme Court made it clear it cares more about judicial efficiency and finality of criminal proceedings than making sure a defendant gets to exercise their right to effective counsel. It held in Shin v. Ramirez that prisoners are accountable for their post-conviction attorney's failures to develop a record of ineffective assistance at trial. In the dissent, Justice Sotomayor called the decision perverse and illogical, saying it gutted the Sixth Amendment's guarantee of right to counsel for those who receive ineffective assistance both at trial and in state post-conviction proceedings.
This statistic from a 2010 Innocence Project study is a bit dated and not directly relevant to our case, but it does highlight how low of a success rate ineffective assistance of counsel claims have. Of the first 255 DNA exonerations, 81% had ineffective assistance claims denied by the courts. Additionally, one study by the National Center for State Courts found that while nearly half of state habeas corpus claims involved allegations of ineffective assistance of counsel, only 8% found relief.
It's fairly easy to see how the Strickland test works in a case that goes to trial. A defense attorney failing to object to something incriminating that was inadmissible under the rules of evidence, for example, could clearly impact a jury's determination of guilt. It's a little less clear in a case where a defendant took a plea, but in Hill v. Lockhart, the Supreme Court clarifies, the defendant must show that there is a reasonable probability that, but for counsel's errors, he would not have pleaded guilty and would have insisted on going to trial.
Wait, hold up, Lauren. I am a bit confused because we've seen emails between Perkins and Mark speaking on Christian's behalf that date back to June 2019. And Perkins, who declined to be interviewed by us, said he was fine either way, to facilitate the plea or go to trial. And Mark pressed him for immediate options as he was concerned about Christian's state of mind. They instructed Perkins to pursue the plea. So what error exactly did Perkins supposedly make?
Here's what Spicer told us.
You can't tell a client, look, this is a great plea deal, right? Versus trial until you've done investigation. How can you tell Christian, this is what you're risking if you go to trial, if you don't know what the witnesses are going to say?
She told us her goal with Christian's case was the same as with her typical ineffective assistance of counsel cases. She regularly works with Zook and says they begin by gathering everything they can from the initial case, from the plea paperwork and attorney's files to police reports, court transcripts, etc. They comb through and absorb it in order to structure their own investigation, or reinvestigation actually. She says they track witnesses down and re-interview every person whose name comes up.
That's why Zook eventually spoke to everyone at Power's Pet Emergency about Storm.
Right, and those interviews even include the plea lawyer. And they'll scope out the scene where events relative to the case played out. For Christian, they went to Andrea and Christian's former apartment and took pictures, even measurements from the balcony. And they'll often travel. In this case, that meant a flight to New England to sit down with Andrea in the presence of her lawyer.
So you just do a really thorough investigation, and then always kind of comparing that against what in this case, what the plea lawyer did or did not do. And in this case, the plea lawyer did not do any investigation.
After the investigation comes the draft of a plea petition, which outlines claims backed up by case law.
You don't have to prove everything in the petition. You just have to present the court with enough information that if it were true, that would bring you relief. If these claims were true, that would mean you have an unconstitutionally sound conviction.
Once the petition is filed, the prosecution's given time to respond. After the judge receives their response, the judge can grant an evidentiary hearing or deny it. If an evidentiary hearing is granted, Spicer says the best practice is to have what's called a Strickland expert.
You want to have a lawyer who is very reputable, whose work you're familiar with, who's, as thorough and dogged as Troy and I are, to come in and testify about what the plea lawyer should have done, what they didn't do, and how that adversely affected the outcome of the case.
At that hearing, her goal would be to get the plea withdrawn. Then, she says she would approach the prosecution to essentially say, look, you've heard all the evidence.
We would have put on all the vets. They all would have come in and testified that, one, they were never interviewed by Perkins, but more importantly, that they never said these things that Cheney said in the affidavit, right? That they never talked to Cheney. Those vets were amazing. They would have had terrific testimony. Having Cheney in there, sometimes just serving a cop with a subpoena is enough to send a message. We could have brought Cheney in and just asked her questions about the affidavit, right? Because everything she would have said would have been contradicted by these veterinarians. We would have put on a really good hearing, and it would have been, I think, very instructive for the prosecutor. Always good for young prosecutors to see things from experienced lawyers. That's how they learn and how they learn to be better lawyers. We would have made a really good case that, Christian is not guilty. they have a mandate to seek justice. They just define it very differently than I think the rules of professional responsibility do. But in the interest of justice, you really should dismiss this.
But what if the prosecution decided not to dismiss the charges, despite hearing all the evidence? In most ineffective assistance of counsel cases, the worst has already happened, right? The client is behind bars or on death row, so things can only stay the same or get better. But in Christian's case, things could get worse. He could face charges all over again and possibly get convicted at trial.
Regardless of the discrepancies between Corporal Cheney's affidavit and the vet's statements regarding the cause of Storm's injuries, the DA's office thinks they have a strong case. In former Deputy DA Jeff Lindsay's words,
the outcome of the case was an appropriate outcome of the case based on our reading of the facts. The allegation is this guy throws the cat off of the balcony or something, I guess, and could the cat have been pushed, or could most cats aren't going to be on balconies and just fall off of a balcony. So I just don't see it as that severe of an issue. We would have prosecuted this case regardless of a vet statement. I don't believe how the injury occurred is material to the prosecution because the charge was failure to get care.
Remember, the DA takes animal cruelty cases very seriously. So much so, they created a special animal cruelty unit. Maybe the DA would take this case even more seriously than before, were it to go to trial now. And Corporal Cheney insists she did speak to the vets and has an extensive recollection of her conversation with Dr. Walker.
when confronted with multiple versions of events, the jury, or the judge in a bench trial, gets to decide who they believe. Hearing from people live in person can leave a different impression than words on paper. They could decide Corporal Cheney is more credible than the vets and conclude that the conversations happened as she says. Witnesses can be wild cards in court. Even though the veterinarians made strong, clear statements that they couldn't say Storm's injuries were human-caused, what if their demeanor in court or their responses on cross-examination, down to minor intonation, somehow left a jury unconvinced?
We heard from former Deputy DA Lindsay that medical experts often make strong statements about causation and then hedge in writing. He was unconcerned about that impacting the prosecution's chances of prevailing at trial. Corporal Cheney's supervisor, Lindsay Vigna, also treated the discrepancies between the affidavit and the vet statements as no big deal. A judge or jury could certainly take that position as well.
And there will still be those injured animal photos and possible negative assumptions about Christian because he's autistic.
Spicer says if the DA's office decided to continue to prosecute Christian after the plea withdrawal, and if she was the trial attorney,
because that was something that hadn't been discussed with Christian and his family,
I would say this would be a good case to try. I can never tell you, oh, we'll absolutely win.
With or without a thorough investigation, some risk of conviction is always there when a defendant exercises their right to trial. This is one of the reasons many scholars are critical of plea bargaining, because as University of Chicago law professor Albert Alschuler says, it's to every defendant's advantage, whether guilty or innocent, to accept the plea. Prosecutors tend to offer plea deals that are just attractive enough to make going to trial too big of a risk, even when the defendant is innocent.
Spicer told us if the case had to go to trial, she believes jury selection would go well.
You'd pick a jury that hopefully isn't a bunch of super-duper cat lovers. There are ways to vet the jurors so that you don't end up with a whole jury of people who are animal rights all the way, right?
And even if Christian was convicted at trial, she's confident that since he took a deferred sentence previously, he wouldn't receive a jail sentence. His worst fear.
Okay, so best case scenario. Spicer wins the motion to withdraw the plea, and the DA's office decides to dismiss the charges in the interest of justice. Worst case scenario. Spicer wins the motion, and the DA's office decides to continue prosecuting Christian, and he gets convicted at trial. This is where the timeline of our story jumps forward a bit. The pandemic came along in spring 2020 and slowed the world down, including court cases, many of which moved online as courtrooms shuttered. But after a 9-month investigation conducted alongside other casework, on September 29, 2020, Spicer filed a motion to withdraw the plea, claiming Perkins rendered ineffective assistance of counsel primarily because he failed to do any investigation at all.
On December 14, 2020, the prosecution responded to that motion, saying it was moot, that there was no issue for the court to resolve because the plea had already been withdrawn and charges had been dismissed with prejudice, meaning they can't be refiled. Remember, one of the benefits of the plea bargain was that if Christian successfully completed the terms of the deferred sentence, the guilty plea would be withdrawn and the remaining charge would be dismissed. Well, he did successfully complete the terms, and on November 2nd, 2020, that's what happened.
The prosecution further argued that even if the court didn't deem the motion moot, the defendant couldn't show a fair and just reason for the withdrawal of the plea. He couldn't show that justice would be subverted if the motion was denied, because the ultimate goal of the motion was to have the case dismissed. The case had already been dismissed.
As to ineffective assistance of counsel, the prosecution said that the motion failed to meet the second part of the Strickland test, that it didn't show the case would have had a different outcome with competent counsel. The prosecution argued that the ultimate outcome being sought was dismissal, and that's the very outcome that resulted from the deferred judgment and sentence.
That reminds me of Serial Season 1 and Adnan Syed's appeal, in which his representation argued around his initial counsel failing to interview an alibi witness. The Maryland Court of Appeals ruled against him, essentially saying, yes, the first prong of Strickland was met because the attorney was deficient. But the second prong wasn't, because the court said the outcome wouldn't have been changed had the witness been interviewed. The federal Supreme Court later declined to take up the case.
In Christian's case, the court issues an order that agrees with the prosecution, finding the claim was moot. On March 5, 2021, Spicer files a response to the court's order, saying that the law allows a defendant to bring claims of ineffective assistance to challenge the underlying guilty plea, even when they've completed the terms of the deferred sentence. The court says it was advised the defendant had decided not to pursue his ineffective assistance of counsel claim, and thus deemed the motion moot, but in no way intended to preclude the defendant from pursuing his claims pursuant to law.
The court didn't rule on the prosecution's other arguments about the defendant failing to show a fair and just reason for withdrawing the plea, and failing to meet the second prong of the Strickland test, that the outcome would have been different with a competent attorney. We asked Spicer if it could be argued that accepting a plea was the best course of action for Christian, because if there had been no attempt to withdraw it, it would have provided him a certain outcome and brought the legal process to an end much more quickly.
And I don't think I could ever go there, because then that brings the standard of practice down for everybody, whether you're on the spectrum or not. But it brings the standard of practice down for people who are on the spectrum, and that's not acceptable. You are entitled to have a lawyer who achieves a constitutional result. And what Bryson Perkins did, even if it was more comfortable for Christian, was not constitutional. Making it quicker and faster, it doesn't benefit anybody, and it doesn't benefit the system as a whole.
Remember how the Supreme Court in Strickland said even the best criminal defense attorneys would not defend a particular client in the same way? Well, law professor Al Schuler thinks the decision to plead to something a defendant didn't do has to be left up to the defendant themselves when they're faced with a coercive offer. He says, I think you're morally entitled to lie, but it's more courageous morally to insist on the truth, even if you have to pay a terrible price.
It's why, for Christian and his family, an Alford plea would have struck an acceptable balance between justice, Christian maintaining his innocence, and mitigation of risk, ensuring Christian wasn't convicted of a crime.
But a standard guilty plea was so unacceptable to them that they spared no expense in seeking to withdraw it.
Christian's family spent around $70,000 pursuing the withdrawal of Christian's plea, around $40,000 on Spicer's attorney's fees, around $20,000 for Zook's investigation, $7,000 for the Strickland expert, who never came into play, as well as a couple grand in travel expenses for Spicer and Zook's trip to New England to interview Andrea. Says Spicer,
Post-conviction is expensive because you have to go back through everything. Mark told us to treat it like it was a homicide.
Zook says the same, that he was told to treat it like a murder, and the goal was to clear Christian's name initially, But then a second focus of holding Cheney accountable took hold as a guiding point to his investigation. And he says,
I was spending money like crazy before Catherine got involved.
Mark confirmed to us that he communicated that money was not a concern. He wanted it done right. According to Zook, the New England trip was a necessary part of the investigation.
Absolutely. In-person interviews are much, much more valuable. And you get a lot more information. And, it's open-ended.
He says it took 3 attempts to finally get Andrea to sit down with them to talk.
They also say that Perkins should have done a similar investigation, hence their assertion of ineffective assistance of counsel.
Before you can, advise your client to plead guilty, you have to know the case. That's what bothered me about the case right up front. This is not a $2,500 case. Right up front, I knew it was a $20,000 investigation to do a good job. You really have to go the extra mile. You got to turn every page. You really have a burden. It's almost as difficult as prosecutions to prove your case.
Perkins charged $5,000 for his services. While it's difficult to determine what any specific criminal case will likely cost, a quick Google search shows attorney's fees for misdemeanors, including trial, tend to range from $1,500 to $10,000.
In my experience, that's a pretty accurate cost range, though, of course, there are attorneys who charge more and cases that require more. But the average criminal defendant isn't going to have $20,000 to spend on investigation alone, not to mention tens of thousands of dollars on attorney's fees.
Christian could not have afforded to spend that much without his parents' help.
Spicer says,
he would have qualified for the public defender, and he would have gotten this type of defense. They are armed with investigators, they're armed with social workers, they're armed with paralegals and administrative assistants, and gobs of lawyers.
She notes that she and Zook both started inside the public defender's office. She specifically vouches for Colorado's system as the model of what you do to effectively represent your client. Zook calls it one of the best public defender systems in the country. They say a public defender should have and would have done exactly what they did on this case, that the public defender's office greenlights investigative costs and travel costs all the time.
But between 2020 and 2022, the Office of the Colorado State Public Defender handled nearly 200,000 cases. It spent, on average, roughly $550 per case.
Ultimately, the family decided not to move forward with the attempt to withdraw the plea based on ineffective assistance of counsel. Spicer would have preferred to go ahead, but the judge grants her motion to withdraw his counsel in June 2021.
I loved how much Mark was going to bat for his son. I have a lot of post-conviction cases where parents don't even go visit their kids. They don't even put money on the phone to call them. And Mark, he really was extraordinary in that sense. His advocacy for his son was extraordinary. And I would have loved to have been able to do a hearing. For Christian to see that there were people who really believed in him and know that he didn't do anything wrong. I mean, frankly, Christian was abused by his girlfriend. That's what was clear to me when we met her. It became very clear. She was very abusive to him. And this often happens to people who are vulnerable for whatever reason, right? Is they are the ones who end up in court.
Law professor Al Schiller says he's wondered if our justice system isn't close to the worst criminal justice system in the world. It's probably not as bad as the systems where they cut off hands for minor offenses, but maybe it's on par with systems where judges take bribes, he says. Those systems are less expensive and may result in justice just about as often, while ours is wonderful for prosecutors, defense attorneys, and judges, but not good for victims, defendants, or the public.
As if to prove his point, regardless of the outcome for Christian, the attorneys who represented him made money. The lives of the prosecutors on the case weren't substantially altered by it. And all the system professionals are connected in one way or another. The original assistant district attorney assigned to Christian's case went to work as a defense attorney with Bryson Perkins, Christian's first lawyer, a month before Christian took the plea. Way back in 2008, Spicer, Christian's post-conviction attorney, and Doug Miles, the judge who presided over his case, were both finalists for the same judgeship. The seat didn't go to either of them that year, but Miles was appointed to a judgeship in 2010. He spent 23 years as a prosecutor at the DA's office before becoming a judge in the same district. During that time, Miles worked with Howard Black as co-founder of DIVERT, the Domestic Violence Enhanced Response Team we first mentioned in episode 2. Corporal Cheney was once a DIVERT officer.
And Black, who we first interviewed while retired from the Colorado Springs Police Department, went back to work during the pandemic as the Public Information Officer for the DA's office under the new DA, Michael Allen. Meaning the same story we first brought to him for expert comment, we now had to re-present to him officially when we came to register questions over Cheney's discrepancy in her affidavit. We'll get to that.
There's evidence throughout this story that some of the system professionals messed up. But none of these potential failings triggered any system repercussions. Unlike Christian, their alleged failures weren't met with criminal charges or any consequences at all.
I mean, these systems are so complex. One small mistake, like a human error, can literally change the path of an entire individual or family. So there's so many opportunities there for human error.
That's Amber Patak, a systems thinker who spent years working on the Green Book project. It was a federally funded, multidisciplinary collaborative effort between 17 partner agencies that looked at the system-wide responses to the co-occurrence of domestic violence and child maltreatment. In fact, the Green Book project included collaboration with DIVERT.
The burden is placed on families. The burden is not on the system. The system just does what it's designed to do.
The minute someone is brought into the system, they're fighting to get out of it. Once someone is labeled a perpetrator or is a defendant in a case, they're trying desperately to prove their innocence. Patak is now the CEO of Community Health Partnership, an organization pioneering a process of collaborative leadership that results in measurable improvement in health outcomes. She's spent more than 2 decades helping organizations develop institutional empathy, creating awareness of how the system as a whole impacts the people who get caught up in it, and finding ways to make the experience and outcomes better for everyone.
You don't enter this line of work if you don't care about people and if you don't care about good outcomes. I think that, the majority of people care about the outcome, a good outcome. But what is not understood is, to your point earlier, even people in the system have no idea what the other parts of the system are doing. They have no idea what's going on. And the only way we get around that right now is to bring everyone in the room and constantly talk about what is it that you do. What we learned is that 99.9% of the time, all of these people just want to help, right? They're not being malicious by saying you should talk to this person or you should do this, right? Like, people want to be helpful wherever they are in the system. Empathy across this entire system isn't the problem. What is often the problem is this fear of being sued or feeling liable for if something really bad does happen in the future. So controlling something that hasn't happened yet is often the response. People compartmentalize when they're at work. If they were really thinking about individuals and the impact that they're responsible, they would crumble, right? Because their heart's in it. They really want to do good work. But when you go to work, you put your work here, and then the families become separate, and what you're trying to do is keep your job.
Some might see Corporal Cheney as a villain in this story, misrepresenting what the vet said in order to make the case against Christian seem stronger. But it's much more likely Cheney wasn't really thinking about the impact her actions would have on Christian, or the young couple's relationship, and perhaps was operating out of fear that not acting might lead to something even worse happening to Storm or Andrea that Cheney could have prevented.
As Corporal Cheney told us,
after 21 and a half years of dealing with people who literally mutilate and beat their animals to death, then it really affects you.
but well-intentioned or not, Corporal Cheney's actions contributed to the breakup of a 4-year relationship, Andrea uprooting her entire life, and Christian's sense of self and security shattering. And no one else in the system double-checked Cheney's work. Her supervisors at the Humane Society didn't validate the claims in the affidavit, saying scrutiny of the claims was up to the prosecutor or by a defense attorney at trial.
Assistant Director for Animal Law Enforcement, Lindsay Vigna, told us,
certainly the prosecutor's job to say, I can prove that beyond a reasonable doubt, this happened. And if they can't, then they have to make those, amended charges or dismiss the case. I mean, obviously, in the court of law, those discrepancies can be brought forward, which is the beauty of our justice system.
Even if Corporal Cheney's supervisors saw themselves as a check, they don't have the time to review every affidavit. Animal law enforcement officers can handle up to 10 calls a day and write summons and complaints in thousands of cases.
The other reality that these organizations are really struggling with is time. Right? They are overwhelmed. The system itself is overwhelmed. They don't have enough people doing the work that needs to be done in order to support these families. I mean, you'll hear that from every single person that you talk to. The number of cases that these DAs are looking at, they're like, which ones can I get rid of? Which ones can I win? Which ones should we just dismiss? It's a real factor, unfortunately, but it's one of the reasons why the system's failing. We just don't have the capacity. The system doesn't have capacity to do what they were designed to do.
Given their incredibly high caseloads, it's not surprising that the 4th Judicial DA's office, the busiest in Colorado, didn't validate the statements in Corporal Cheney's affidavit either. Assistant DA Lindsay told us,
I guess we don't look at it that closely, in the sense that we're looking at for, any discrepancies. We're just looking at more or less as a police report. And so when you read this police report, and then you kind of understand the rest of the case, the facts of the case, we're going to see how those jive.
sources we spoke with during our investigation, on the condition of anonymity, because they were concerned with possible retaliation, told us that prosecutors inside the DA's office deal with high caseloads in a high turnover environment, where there's constant pressure to secure convictions. We've been told this means cases at this DA's office do not receive an appropriate amount of investigation, attention, and expertise.
They, of course, would refute that. But as a journalist, I find it troublesome that prosecutors aren't required to do the same degree of fact-checking we are. Prosecuting someone on unverified statements can lead to conviction and imprisonment, and undoing a faulty conviction takes a lot of additional legal procedures. Publishing a story with unverified statements, which, let me tell you, we try never to do, rarely leads to the same amount of harm, and it can be mitigated by publishing a correction, retraction, or apology.
And there's no consequence for defense attorneys not fact-checking either. A court's decision that a defense attorney rendered ineffective assistance of counsel doesn't impact the attorney in any meaningful way. It doesn't trigger an automatic investigation into their fitness to practice.
So when a system professional makes a mistake that massively impacts multiple lives, the burden is placed on the people who've been harmed by the mistake to navigate the system and prove a mistake was made, essentially forcing them to prove their innocence, or, not guilt.
Throughout our criminal justice system, the burden is placed on people without subject matter expertise, familiarity with the process, or teams of employees to help them file paperwork, meet deadlines, and make sure they're doing everything that is expected of them. They're having to meet all the requirements of the system while still managing the rest of their lives. They are the least equipped to navigate all this stuff, and yet they suffer all the consequences if the system doesn't agree a mistake has been made.
No one's seeing the full picture. Law enforcement creates A and B, then they transfer it over and then they're done until they come back at like maybe step L or something, but no one has the full picture. No one. And the only way we would get through of really revealing all of these big challenges is by having all of these disciplines in a room to actually see how it plays out at a systems level. But what often happens is that when you bring people together from organizations and you start talking about the problems that we are creating, that I am creating as an organization, that we all are creating, the problems, they're more likely to blame each other than they are to take responsibility. And so in any systems change effort, that trust building, relationship building is so critical to actually improving a system. But it rarely happens because this takes a long time. Changing any system is a really long time.
Patak says the Green Book team undertook a process called institutional ethnography, during which they reviewed one sample case at a time, sometimes for as long as 6 months, following the exhaustive paper trail, just as ineffective assistance of counsel attorneys, private investigators, or journalists might. They'd establish timelines and map it all out.
So look at how many touch points I had to have as a result of one call for help. Now I have 75 people that I need to talk to, all requesting a different set of information from me, all because it satisfies something that you think you need that you actually don't need. And so much of it is rooted in paper, which is another problem.
Patak says the results of an institutional ethnography can be powerful. Friendships between organizations develop, and trust follows.
They develop institutional empathy, so all of a sudden, not only am I concerned about my own organization, but just having conversation with you, I'm starting to understand you and the restraints that you have in order to do your job. That institutional empathy is also really important and can only happen when people are sitting in the room and talking to each other. And mapping out some of those things and then asking these people at every point, what could have been done differently? And then the solutions come from the organizations or the system itself, because that's typically where they need to come from. And every systems change effort, it requires a champion in every single one of those organizations. If you don't have a champion, it's done.
Patak says Divert benefited from an early champion now familiar to us.
When you have someone like a Howard Black, Howard was one of those unique human beings that had no problem saying we could have done this better. His reputation was strong enough at CSPD where he could get away with that, and he could slowly sort of chip away at change.
Admittedly, Lauren and I took heart in hearing Patak say this about Black, because our initial sit down with him to learn about Divert was highly informative. He was a pretty open book. Now, he would be our media point of contact inside the DA's office as we brought forth evidence revealed in our reporting regarding the accuracy of Cheney's affidavit. Would he play whatever part he could do to be a champion for change this time? I mean, sure, he'd be a familiar face as far as communications went, but we knew that his role as a go-between for the media meant he would be limited in sharing only what the prosecutors at the DA's office authorized. Law enforcement PIOs are essentially gatekeepers that control external messaging to their communities. They don't typically comment to reporters in depth or at all on active investigations that could compromise cases. But part of their duty is to coordinate open records requests and disseminate data and documents, such as crime stats, or they'll field specific requests about budget or personnel info, something relative to a hard news story in a local newspaper or a TV segment.
So it wouldn't really be up to Black to do anything other than get our questions into the right hands. It would be up to the new DA, Michael Allen, or one of his higher-ups, to do the review of Christian's case. By this point, we had published an abbreviated version of our story in the local media, at the alt-weekly newspaper Matthew works for, which put some degree of scrutiny and public pressure on the DA's office to take this seriously.
Lauren spent days preparing what became an 8-page, extremely detailed overview of inaccuracies in and issues with Corporal Cheney's affidavit. It was written in all the legalese she knows how to command, thanks to her prior criminal defense work. Surely they would have to say or do something meaningful in response.
Black received our summary packet and a list of questions, and gave us the official quote that it was under active review.
In the next episode, 6 months will pass before we get answers. Meanwhile, we try to find out who holds animal law enforcement officers accountable. Corporal Cheney tells more of her side of the story, acknowledging that the system fails animal law enforcement officers too. And since he didn't have his day in court, we give Christian the last word.
I would love for him to be vindicated. I would love for him to be able to have a clean slate moving forward as far as his record goes.
It was just a system. You're just supposed to go through it, and nobody's supposed to actually care whether or not anything's true. And then it spits you out and, assigns you a value, guilty or not guilty.
You see some crazy stuff in law enforcement, especially if that kind of job, and it really affects you. You can become emotionally involved, compassion fatigue is a real thing.
Vulnerable Creatures is written, directed, and hosted by Lauren Hugg and Matthew Schnipper, and produced by Vehement Visuals in Colorado Springs. Original music by Michael Johnson and Dave Pastor. Logo design by Ryan Hannigan. Special thanks to our Patreon supporters. In this episode, we mentioned the Serial podcast. Here's an update on that case. After primary production on this episode was completed, a Baltimore City judge vacated Adnan Syed's conviction upon a motion by the state's attorney. The prosecution's motion detailed multiple reasons why it no longer had faith in the integrity of the conviction. It also noted for the court the misconduct of one of the two investigating detectives in a different case. The prosecution said the continued incarceration of Syed while the investigation proceeds would be a miscarriage of justice.